So now that you are still young, it is good for you to have all this preparation. You see, the Bible says in Proverbs chapter 13, verse 22, that a good man leaves an inheritance to his children's children. So inheritance is not only about money. It is about order. It's about structure and about clarity. So today, I want every one of us to open our heart, open our mind. We should be ready to ask questions and to take notes and participate actively. Those of us who are online, please, there is no distance in the realm of the spirit. As much as possible, take away every distractions from you, because this is a topic, or these are discussions that people don't want to talk about, but they are the inevitables of life. So try as much as possible to be fully here, fully engaged, and prepare your questions, because we're going to be having question and answer session where we can entertain questions from all as sundry. So the information you receive here today may save your family from future confusion, from future conflicts, and from future crisis. So my prayer is that God Almighty will grant us wisdom. So on that, I announce that this program is now open in the name of God the Father, Jesus the Son, and by the power of the Holy Spirit. Amen.
Thank you, Pastor Sheon. Thank you, Pastor Sheon, for that profound charge. Indeed, wealth preservation and legacy is beyond death and distribution. It goes to sustainability and continuity and how we pass across those assets to generations. To take this conversation further, I want to invite the speaker, Mr. Ayo Fakolade. He's the founder and managing partner of Compleo Legal. He received an LLB from the University of Ibadan, from the Nigerian Law School, and he had an LLM from Northwestern Pritzker School of Law, Chicago, Illinois. He also has a certificate in private equity from the Private Equity Institute, London Business School. Ayo is a dual admitted New York State and Nigerian attorney. He has significant, extensive, and diverse expertise and experience in commercial law, from practicing law over 2 decades. Ayo is also an independent scholar who researches and writes on issues related to the digital economy, culture, and law in Africa. If our hands are not too busy, please let's welcome Mr. Ayo Fakolade.
Thank you. Good morning, everyone. It's a pleasure to be here to talk about this interesting topic. While I was listening to Pastor talk, when he gave us his charge, a scripture came to mind, which he also mentioned, that the Bible says that a good man leaves an inheritance for his children's children. And it's an interesting point, because on this point about wealth, there is some form of consensus that wealth doesn't pass through 3 generations. There's this cultural proverb that says from short sleeves to short sleeves in 3 generations. First generation builds the wealth, second generation manages it, the third generation squanders it. Not all the time, but it does happen. So, sorry, is the presentation going to be shown? I don't know. Okay, all right. So in terms of wealth preservation, legacy planning, and transfers, please could you go to the next slide? Okay, so that's the outline. The things we are going to talk about right there. Aim of wealth preservation and planning, applicable principles, wealth categories, voluntary and involuntary transfers, wealth preservation and transfer tools, and some issues with wealth preservation and transfers. And we're also going to have a few live experiments as we go along, so we're enjoying everybody to please cooperate and participate. Okay, next slide, please. So now when we talk about why wealth preservation and transfers, so it's a personal thing, you know. Obviously, you know, people that own their wealth will have their reasons why they want to preserve it or transfer it. You know, they might have different objectives, you know. You might want to provide for people, you might want to give to good causes, you know, you might want to prevent disputes, you know, it's a personal thing. So really, that will determine. But clearly, it's an opportunity for you to make provision for certain people. It could be your dependents. It could be for good causes. You want clarity. You also want to prevent disputes because it can be a contentious issue. Like Pastor said, sometimes wealth becomes warfare and assets become arguments. It's something that is pretty common. Can we move to the next slide, please? Yes. So in terms of, I want to talk about, say a few things about 5 principles. And everything else I'm going to say today is related to this in different ways. So the first one is time value of money. And what time value of money means for our purposes is that it's always better for you to get 1 naira today than tomorrow. Why? Because you can put that 1 naira to work. It can generate interest. It can generate a return. You can put that money to work. It can start to generate a return. That's one. The second principle is about compound interest or compound return. So what it says is that in most cases, an investment, the return or the interest on an investment will compound over time. Now, the way compounding works is like it's more of multiplication than addition. More like geometric progression compared to arithmetic progression. And I'll make a reference. Let's say you invest 1,000 naira now, today. You invest it for 30 days. And you get a return. So this is just for simplicity purposes. You get a return of 100 naira. So at the end of the month, that is 1,100. If you roll over that investment, so you're now starting with 1,100. If you get the same return of 10%, so at the end of month 2, it won't be just 1,000 plus 100 plus 100. It's going to be 10% of that one. So that's what we mean by compound, that over a long period of time, the return on the investment can compound. And that leads to the third point, that start with what you have. Now, that's actually the title of a book by Pastor Sam Adeyemi. We'll come back to that issue. We'll still talk about books generally later. But you can start where you are. And there's a saying that the day you start to generate income, that's the day you should start planning for your retirement, or the day you should start to invest. Some people will tell you that, I want to hit a certain threshold, I want to wait till I have this, I have that. No, once you start generating income, just start with what you have, start where you are, and then you see, and that's also how you can get that principle of compound interest to work for you. You don't need to wait, just start with what you have. And I'll give you an example. Several years ago, over a decade ago, before you could invest in a collective mutual fund, I think you needed a minimum of 50,000. But it took it down to 5,000 naira. And somebody in the industry was telling me that when they made that change, it really increased the amount of people investing and the volume. So even with 5,000 naira, you could open an account, a mutual fund account, and then start to work for you. Could we show that slide, please? Okay. And then the fourth one is collective action. Now, in terms of collective action, I'm going to revert to a scripture and a Yoruba proverb. So there's a scripture that says that 1 will put 1,000 to flight. 2 will put 10,000 to flight. The Yoruba proverb says that Olowo kan láàrin òtòṣì mẹ́wàá, òtòṣì ni gbogbo wọn. So the first one is positive. What it's telling you is that when 2 people work together, the return can be exponential. So 1 person 1,000, 2,000. It's not 1 person 1,000, 1,000, 2,000. The second one tells you that, no matter how successful you are, so let me translate that proverb. So what it means is that, what it means is that one wealthy man in the midst of 10 people, the wealthy man and the poor people, they are all poor. So what it means, it still shows that principle of collective action, just from a negative place and a collective influence, that the 10 poor people can overwhelm that wealthy person. But I think the more instructive thing is the power of synergy. 1 putting 1,000 to flight and then 2 putting 10,000 to flight. And that leads me to the next principle. But I'm going to ask a question. Did anybody notice the because there is a link, or there is a similar reference between the scripture and the IREAL proverb. Did anybody notice the reference? Can anybody tell us? I'll give you an hint. It's a number. Anybody? Anybody? Not one. Anybody else? Anybody else wants to try? Okay, so the reference is 10. Remember, 2 will put 10,000. Then Otoshimewa, that mewa is 10. And the next principle is attention, analysis, and action. I put a bracket there because I didn't want to state it. I wanted to see if anybody would notice. So it's very important that you pay adequate attention to what's going on around you. You do appropriate analysis, and then you take the necessary action. And I'm going to give some references. 25 years ago, Nigeria was very different, especially in terms of our economy. And I'm going to talk about 3 examples: the pension industry, the payments industry, and so pension, payments, and I'll come to the third one. So in terms of, telecoms, pension, and payments. So in terms of telecoms, 25 years ago, maybe we had 500 connected lines or 1 million, something very small. And the government now issued licenses, did an auction in 2011 or thereabout. Yes, did an auction for licenses. And some people won these licenses. But at that point in time, we're just 2 years into democracy. In fact, one former minister of communications, retired general, and former senator said, telephone is for poor people, So, and I'll still get to that. Telephone is for everybody, but I'm going to give some figures before I do that. But we've seen that telephone is for everybody. So anyway, some people bid for the licenses. Some people had the opportunity to, but they did not bid. Now, one of these companies today has 89.5 million subscribers. I don't think there is any other company in Nigeria that has that amount of subscribers in terms of just amount of customers, direct customers. So it just shows you how, some people looked at it, they saw uncertainty, but some people looked at it and did some analysis and took action. And now today, they're really reaping a significant return on their investment. You understand? For instance, now, NCC report also told us that in the first quarter of this year, NCC is the Nigerian Communications Commission, which is the regulatory body for telecoms, told us that in the first quarter of this year, Nigerians spent 3.3 trillion naira on data. So that's an average of 1.1 trillion every month. Lagos State's budget for this year. Now, a budget is a forecast. It's forecast of income, forecast of expenditure, so it doesn't mean you generate all that income or spend all of it. But let's even assume they do that. Lagos State budget for this year is 4.4 trillion naira. So that's the money Lagos is expected to generate and spend throughout the year. That's what people are spending on data in just 4 months. Not even talking about airtime, just data. So that shows you the size of the telecommunications industry, the way it's grown. The second example is about pensions. 22 years ago, we also evolved into a contributory pension scheme. Before that, it was defined benefits. Civil servants would be paid, at the end. And we had serious problems with that. There are few private companies that probably had pension schemes. But it was a big problem. So we evolved into a contributory pension scheme where both the employer and the employee will set money aside every month. Then again, some investors also got licenses either to operate as a pension fund administrator or pension fund custodian. And the industry too has also grown. I mean, as at first quarter of this year, they probably have over 30 trillion in assets under management. And if you look at it, there's still a lot of room to grow because I think there are just about maybe 10 million active subscribers. The last point in terms of attention analysis and action has to do with payments. Now, typically, before it was the banks, just the deposit banks that used to process payments. And some companies, and clearly if you look at it objectively, there are some areas, there are some people that have been unserved and underserved. And some financial technology companies, fintech companies, about a decade ago, some of them started operating in this space. About a year ago, I was at an event, and the MD of one of these big banks was there, and someone was just talking about opportunities, and he said there are opportunities everywhere, even where there is established competition. And he said that, for instance, now, and this a year ago, that these fintech companies were processing 25% of payments from zero in like 10 years ago. They're now processing 25% of payments. Even the banks now, a few years ago, they too have set up subsidiary companies that they too are doing payments, because they've seen the size. So it just shows you what's possible when you pay attention, when you do your right analysis, and then you take necessary action. I also want to ask one or two questions here. Has anybody here invested with another person? Have you invested, at least two of you run an investment together? Any type of investment, whether it's formal or informal, anything. If you've done that, please raise up your hand. 1, 2, 3, 4, 5. Okay. That's 5 people. Okay. How many people, if you don't have a mobile phone, if you don't have a mobile phone, raise your hand. So everybody has a mobile phone. If you have more than one active mobile phone, raise your hand. Okay. So we can see that at least, I think we're about, how many people here now? Maybe about 50 or thereabout. So out of 50, now this is a small sample. It's not even necessarily representative of everybody here, because I know there are other events going on. But you can see out of this place, everybody has a mobile phone. Some people have 2. And we've seen that a mobile phone is actually an effective business tool. In fact, some of these big, and sorry, then one last question. How many, if you have a social media account, at least one active social media account, raise up your hand. What? Okay. If you have 2, raise up your hand. Raise up 2 hands. Okay, fine. So you can see now that virtually everybody has a mobile phone. At least 90% of people here have an active social media account. Those are the people contributing to the 1.1 trillion data spend every month. But when it comes to collective investment, at least in this place, just about 5 out of 50, just about 10% of people are doing collective investment. Has anybody else, minus the people that raise up their hands in terms of collective investment, has anybody else invested in a mutual fund before? Okay, but most of them are the same people. So just a little bit more. So you can see our approach to collective investment compared to our approach to having the mobile phone, and also compared to our approach to having a social media account. So you can draw whatever conclusions you want to draw from that yourself. Please, can we move? Can we continue? Okay. So wealth categories. Typically, you can classify it into 2 categories: invisible or visible wealth. Most people tend to focus on visible because it's what we know, is what it's something that's it's visible, and then it's easily convertible. You understand? But invisible wealth is also very important. In fact, it's invisible wealth that's convertible to visible wealth. And invisible wealth, when we talk about invisible wealth, that could be your expertise, it could be your experience, it could be your network, it could be your intellectual property. I'll give you an example. So for instance now, if you're going to write a book, depending on who you are, you would, you approach a publisher, you agree terms with the publisher, and then they'll give you some royalty. But for certain people, the publisher will approach them. from certain leaders, especially former leaders in the United States or United Kingdom, people will approach them and say, oh, please, we want you to write this book. We want to publish for you. And they will give you an advance. Sometimes it's in serious money, millions of dollars or pounds, because they recognize that these leaders have useful experience to share with people. So it's just an example of how an invisible wealth can translate into tangible wealth, and it is something we should pay attention to. It's something we shouldn't neglect, and that, in fact, invisible wealth is what's convertible to visible wealth. I won't say too much about visible wealth because I think it's pretty obvious to most people: money, assets, property, investments, and things like that. Please, can we move to the next slide? So, voluntary and involuntary transfers. So, typically, I've put it into three categories: individual, societal, and survivor's choices. So by individual, obviously, I mean an individual person. You decide how you want to transfer your wealth. We'll talk about the tools later, so I won't dwell too much on that. Societal, by societal, I mean what happens when you don't make that decision. So when you don't make that decision is actually made for you. For instance, we have an administration of estate law that talks about what happens. So broadly speaking, when it comes to succession in law, so when you die, one of the questions is, do you die with testate or intestate? Have you made a provision? Do you have a will, for instance, or you don't have a will? If you have a will, so you apply to call for that will to be administered to probate. If it's valid, then that's that. If you don't have a will, then your representatives, depending on your survivors, will apply to the court for letters of administration. And there are different categories on how your estate will be administered, depending on who are your survivors. Do you have surviving parents? Do you have a surviving spouse? Do you have surviving children? Do you have surviving relatives? So the point is that if you don't make that choice yourself, then society has made that choice for you. You understand? Then when it comes to survivor's choices, this one too is a question of when you haven't made that choice, and the survivors will now decide what to do, and sometimes it becomes a contentious matter. Like Pastor said, wealth becomes warfare, assets becomes argument, and things like that. And so typically, it's preferable for you to make a choice. Like they say, if you fail to plan, you're planning to fail. Or if you don't have a plan, not having a plan itself is a plan. It's just that you default to what society has decided to do. Could you show the next slide? Yes, thank you. So it's about wealth preservation and transfer tools. Now, one of the most important tools is knowledge. You need to have some basic knowledge yourself in terms of wealth, wealth, and then and planning and transfer, but more importantly, just in terms of wealth and investment. Now, Nigeria is a country where we've had so many scams, different scams from, at least I can remember from the time of Nospecto and all these different collective scams that go on. Now, people do those things for different reasons, but one of the reasons why they do is ignorance. Some might be greed, but it's ignorance, because if you at least have some information about how wealth is created, how investment works, you realize that this is a scam, that it can't work. Like people say, if it's too good to be true, then it is really too good to be true. So yourself, you really need to have at least some basic knowledge. And there are some books I'm going to recommend. I'll start with What You Are by Pastor Sam Adeyemi. It's a fantastic book. He's also written another one, The Parable of Dollars. You understand? Those are two books that, you really need to read and understand. And then there's also this book by Ambassador Nimi Akinkugbe, A to Z of, I think it's A to Z of personal investment. I'll check again. And there's another book by Malcolm Gladwell called Outliers, The Story of Success. So so you really need to be able to understand some certain things. If you understand some certain things, then it's less likely you'll be led astray, or be led astray by some fanciful stories that you want to become a billionaire overnight, or, make some imaginary wealth. And personally for me, one of the reasons why I chose Daystar was that I already started reading about Pastor Sam's articles on success power in the newspapers. So by the time I came to Lagos and started working, it was very easy for me to join, because I already had some idea about, okay, these are some things it teaches and things like that. So that issue about personal knowledge is very important. Another tool is advisors. You really need to get appropriate advisors to help you when you're trying to make an investment. Depending on the investment you're trying to make, you will need a financial advisor. You might need a legal advisor. It depends on the nature of the investment. But a great advisor, that understands you, understands where you are, can make a big difference to you. And I'll give you an example. So when the pension scheme started, we just had one fund. But in the last maybe like 10 years or thereabout, the funds have been broken down into different categories. I think fund one, about 5 or 6 funds now. 1, 2, 3, 4. Then I think there is even like a non-interest fund. And what these funds, this differentiation is because of, at a certain point in your life, your investment needs and then your priorities change. So when you're 70, for instance, you might be more focused on conserving your income. So this differentiation of funds is just really to put you in a fund that's more suited to where you are at that point in time. So it's the same thing when it comes to advisors. You really need to get an advisor that understands where you are, understands what you're trying to achieve, and then can help you on that. I have another question. Has anybody else consulted an investment advisor before? If you have, please raise up your hand. 1, 2, 3, 4. Anybody else? 5. Has anybody else contacted a legal advisor before? 1, 2, 3, 4, 5, 6, 7, 8. Okay, so for financial advisor, about 5% of the people here. Legal, you could say 10. So you remember this principle about collective action. So that's it at work again. And I suspect that it's a particularly weak point for us in terms of Nigerians and Africans, that, we don't do enough, to harness that power of the collective, And the truth is that the more we do that, the more likely we are to succeed. So I've spoken about knowledge, I've spoken about advisors. Then there are also different things like a will. You could have a will, you could have a trust. Also there's things called deeds of gifts. But the most important thing is that you really need to decide what's best for you. What's best for you depending on your objectives, depending on your income, and depending on where you are at that point in time. So these are just examples of different tools you can use. Can we go to the next slide, please? Okay, so typically there are also some issues that arise with wealth preservation and transfers. There is a list there. One is neglect. We tend to think that you have all the time, that it's something you can deal with later. You understand? So sometimes we neglect to do these things, Even sometimes when we neglect to do that, we don't delay action. We don't move as quickly as we could. For instance, now, so Lagos State has something called the Blue Book, where they do valuation of properties. So they tend to do this every 10 years. So I think the last one was in 2015. So they recently done another valuation, maybe last month or thereabout. So let's say you had the property and you're not applied for governor's consent within the last 10 years, and you now decide to do that. Easily the amount you can pay to Lagos State could be 2 or 3 times what you'd have paid 2 months ago. So you need to act as quickly as possible and not just delay and think you have all the time. Remember the principle about compound time value of money. and also compound interest. You understand? Then another thing is fragmentation. You might see that for most people, you have investments here and there, but you've done it in a fragmented way. You might have even made some investments, you might have forgotten about it. What you need to do it in an integrated manner. And I'll give an example. For instance, now, you might have made a certain investment, you might have bought some shares, and you haven't what's it called? You haven't done your registered for your dividends with the registrar. You understand? So you typically need to make sure all what you're doing is an integrated matter, and that way so you can get all the benefits you want from it. And because sometimes you have different beneficiaries. It might have been when you started out, you didn't have a child, you didn't have a partner, you might have designated somebody as a beneficiary. And I'm going to give a story about late Chief Frederick Rotimi Alade Williams, one of Nigeria's best lawyers. So late FRA, as is better known, had a will. So he had a will, I think, probably in the 60s or something. It was registered in the probate registry, but he forgot about it. So by the time he died, and when he wrote that will, he had just 2 children. So by the time he died, they actually thought that he died intestate and he didn't have a will. So they started the process of administration. Then later, they now discovered that, Baba actually had a will. But Baba, by that time, I think he had 4 children and 2 children. And of course, they went to court. I don't even think the matter has still been resolved. I think they're still fighting in court. The man died how many years ago? 20 years ago or something. So it's just an example of neglect and fragmentation. These are real life issues that tend to happen. You understand? So you need to avoid all of these issues. Can you show the slide, please? And then, of course, incomplete documents. For instance, that will was incomplete because, and so when you're drafting, when you have a will, a good will should do some scenario planning. Because about the time, at the time when you drafted that will, your circumstances may change later. You understand? So you actually need to make sure that you made provision for possible scenarios. And I'll give another example. So some time ago, some investment companies, some subsidiaries of banks started doing something called a simple will. You understand? Now, a simple will is good. I think that the list, maybe your accounts, just some basic things. You understand? But one, that doesn't cover all your assets. And a simple will is unlikely to do scenario planning for you. You understand? So you just need to make sure, like I said, you have to get the right advisor that's good for you in that circumstance. Can you show the slide, please? We've spoken about the disputes about late Chief FRA's estate. It's still going on. We've spoken about, I gave the reference to Lagos State's valuation, which that's just an example of the additional cost that you can incur when you delay certain things. Can we go to the next slide, please? So, conclusion, we really need to prioritize. You need to make sure you prioritize this issue of your wealth management, planning, and succession. You need to prioritize. It's not something you should delay. You need to also do it in an integrated manner. You need to do it in an integrated manner, not that you're doing it in piecemeal. You've done this here, you've done that, you've even forgotten about some of this. There's a very, when it comes to delay, there's a popular military saying that says delay can be dangerous. You understand? Don't delay things. Don't say, something is in the pipeline. Something that is pipeline might not come out. So thank you very much. I would also take, I guess we'll take questions later on. Thank you.
Thank you so much, Mr. Ayer. Thank you for that wonderful session. From what we can hear you say is that wealth is not, I think, how would I put it, that sometimes we make wealth and it could be lost not because we didn't make it, but because it wasn't properly structured. So now we move to the panel session that is going to be led by Acronym IREAL. So we'll be inviting the panelists. The first panelist is Mr. Felix Ogumade. Mr. Felix is a graduate of Obafemi Awolowo University. He has gone to the Nigerian Bar in 2004. He also holds a master's degree from the University of Lagos. He's a member of the Nigerian Bar and the International Bar Association. Mr. Felix is an associate of the Chartered Institute of Taxation of Nigeria and was appointed as a notary public for Nigeria in 2015. He began his law practice in 2024 with Morka & Co., which specializes in commercial practice and litigation. Also, he saw the need to take on new challenges where he subsequently joined Agape Solicitors in 2008. Mr. Felix ventured to establish a law firm called Felix Ogumade & Co., through which he renders bespoke legal services to teaming clients. Welcome, Mr. Felix. Our next panelist is Jayeola Odubajo. Jaye obtained a bachelor's degree in law from the Ambrose Ali University, Ekpoma. In the year 2000, she was admitted to the Nigerian Bar in 2004, I beg your pardon, and holds a Master's of Law from the University of Lagos. She worked with firms of Abugo and Solicitors and ABFR & Co., from guiding corporate boards through legal frameworks and complex governance issues to negotiating high-value property deals. Jayeola has advised clients across multifaceted commercial transactions, company and company sectorial matters, microfinance banking relationships and transactions. She is the principal consultant of Trust Springs Legal Consultants. Welcome. Our next panelist is Mr. Benjamin Adroja. He's an internationally respected global wealth strategist and fund manager with over 15 years of distinguished experience helping executives, entrepreneurs, professionals, and organizations build, preserve, and multiply wealth. He's the managing director and CEO of Cutting Edge Partners, a premier global financial advisory firm providing bespoke wealth strategy, investment advisory, and financial intelligence solutions to clients across Nigeria. He's the best-selling author of Funding Your Dreams and the convener of the International Conference on Wealth Creation, a biannual platform dedicated to equipping individuals and organizations for long-term business success. Thank you very much. Opeyemi.
All right, thank you very much, Igoma. So I believe we're all here to, okay. So thank you very much and welcome to the speakers. I believe we're all here to make findings and curiosity as to the topic. The topic is wealth preservation, legacy planning and transfer, understanding Nigerian estate laws and processes. So we've compiled a series of questions for the speakers where we are here to also learn from them, having years of experience in these topics. So my first question is, there are trust companies in Nigeria. I think my first question will be going to Mr. Ayo. There are trust companies in Nigeria. Can you give some guides on setting up trust with a trust company in Nigeria?
Okay. Yes, can you hear me?
I can hear you.
Okay, so when it comes to trust companies, I think the first thing that's important for you is to find out this company, does it have a license? You know, so this trust company, does it have a license from the Securities and Exchange Commission? Because you want to be sure you're dealing with an authentic and someone that's reputable. Because before you get your license, there are also certain requirements you need to fill. So this also a point that relates to just choice of companies and intermediaries. You want to find out, does this person have an appropriate license? If he needs a license, is this a professional? And things like that. So then when it comes to trust companies, we are trying to set up a trust. Your choice of company is also going to be influenced by the location of the asset and the nature of the asset. So if the asset is in Nigeria, you might decide you want to use a Nigerian trust company to set up that asset. If it's an offshore asset, you might want to use an offshore asset. But like I said, your wealth planning also has to be integrated. So you also have to make sure that everything you're doing fits together. You understand, and you're not just doing things piecemeal. And clearly a regulated trust company, they have different products, and then so you engage them and decide. You might want to consult one or two, and you compare and you decide what's best for you. And I also want to say something else about next of kin. It's something I wanted to mention during the presentation. So typically, you go to banks, you fill a form, and you fill a form about next of kin. So people want to find out, what does that really mean? But in Nigeria, what it really means is just a notification. So in case the bank is trying to find information and they can't reach the primary account holder, then they can contact the next of kin. It doesn't give you any right over the account. If you're not a signatory to that account, you can't withdraw funds. If the person passes, if he has a will, so after the will has been admitted to probate, then that account will be converted to an estate account. So the fact that you're next of kin on account doesn't mean automatically you have the right to access to that funds. You need to be either a signatory to that account, or that estate has been, or you are now the administrator of the estate of the person after he has passed, and letter of administration or probate has been granted in respect of it. Thank you.
All right.
Please, can I add to? Okay, let's quickly demystify what a trust is. Okay, a trust is a legal arrangement. It's like a legal structure where a person, otherwise called a settlor or grantor, is saying, okay, I'm contacting this person or this institution to help me to what? To take over the administration of my properties or my investment or whatever it is, with a view to being useful to the beneficiaries. So what it means is that you are intentionally planning your legacy. It's beyond will. It's quite different from a will. A will comes into effect right after the death of the person who wrote the will, but the trust can come into effect. It's a living trust. While you're alive, you can even set up a trust for yourself to take care of yourself. So a trust is a very solid wealth preservation tool that we need to really, really leverage in this part of the world. Thank you.
Thank you for the additional words, Mr. Benjamin. So this question goes to you, Mr. Benjamin. Are there any hidden taxes or compliance risk when setting up or transferring assets into trusts?
Okay, so for taxes, candidly, I would say that a trust is a very tax-efficient structure. When, for instance, during your presentation, you were talking about intestate, someone dying without proper will, it goes to what? Probate, it goes to a letter of administration. But when you set up a trust, it's a private transaction. It avoids all that publicity. It avoids the taxes, all of those stuff, the main taxes, the probate fees, the charges, the state fees, all of those things. It avoids all that. So it's you intentionally say, okay, my properties, right while I'm living, I'm transferring the ownership of my trust, of my investment, or my properties to this trust that I'm creating, that this trustee will manage for me, right? And these are the guidelines, the trust deed. That's what they call it. It's a document that contains the guide. You intentionally, okay, this is what and what and what. Now, a will is a distribution, instrument, while a trust does not only distribute, it's a control instrument. This is what I want to distribute, how I want to distribute it, when I want to distribute it, for whom. So, by and large, we say that it avoids a lot of those taxes. So it's not a tax avoidance necessarily, although some high net worth use it as a tax avoidance instrument, but it is not a tax avoidance mechanism. It is a tax efficient instrument because the trustees will take care of all the obligations, right? And then when tax can only come into play when maybe probably capital gains tax, and we can also talk about maybe personal income tax on the part of the beneficiaries. So it's a very, very tax efficient instrument. Thank you.
Thank you. Also, I would like to ask you, Mr. Adeyemi, when you are talking about a trust complaint, can you simplify what trust is to like a 2-year-old that does not have experience as to what you are saying as to trust?
Okay, I think I've shared that already, but let me further demystify it. Okay, so when you are writing a will, it only comes into effect, like I said earlier, after the death of the person writing the will. It is subject to a lot of vicissitudes, it can be contested. For instance, I read of a particular case in Kenya where a gentleman died. He was a very rich man, a politician. He died. And he died in 2016. They're still fighting in court till tomorrow. In fact, someone just got another child. They didn't know another child existed. She went to court and said that she must be included in the will. And she won. But a trust avoids all that. A trust arrangement, in fact, a trust is like an entity on its own. It's a legal entity. Once you transfer your properties to that trust, it's no longer your name. For instance, when you hold a bank or something and they're looking for your properties to seize, they can't seize the properties because they're in the trust. The trust owns them. You can say, I don't own any properties, I don't have any. And legally don't. Because the trust now owns the property. So it is a very powerful wealth preservation tool. It gives structure to legacy planning. And it also contributes to not just continuity of legacy, but the perpetuity of the legacy of the person who sets up the trust.
All right. Thank you for that reply, Mr. Benjamin. Okay, my next question is also on trust. Can the trust complaint be trusted, especially as the assets would need to be transferred to them?
Yes. Now, let's say this. Like he shared earlier, Mr. Ayo shared earlier, trusts entities, or trustees, as we call them, are regulated. And they are licensed by the Securities and Exchange Commission. So they are regulated. There are guidelines, there are frameworks within which they have to operate. Aside from that, you as the grantor, that is the person who is appointing them, you can also appoint someone that is called a protector. Of course, we have different parties in the trust arrangement. We have the grantor, the person setting up the trust. We have the trustee, that is the institution. Then we have the beneficiaries, those whom you are setting the trust for. And then we have the protector. The protector is an external body or an external person who oversees the entire trust, who more or less monitors the trustee company and say, okay, this is what is in the trust deed. Are you aligning with that? So we have several mechanisms in place to ensure that they do normal, like they say in Nigeria, they do normal, that they perform what they're supposed to do based on the trust deed. Aside from that, when you are looking for a trust institution, it behoves of you to what? Do your due diligence. There's quite I don't want to market any company. So there are quite a number of them. Just Google. You see all of them on Google. There are so many of them that you can find. Just do your due diligence, make inquiries. There are some of them that have legacy. They have, they've been there for 40 years, 50 years, and all that. So they have track record. All of these things should come into play when you are selecting a trust institution. Thank you.
Sorry if I may. So he said some very important things on relation to trust, and there's something else we need to remember. Like he said, so once you transfer assets to a trust, you lose ownership, you lose control over that asset. So you also need to be sure that you want to lose control over that asset. You understand? Because it takes effect from when you are alive. So you might still you have to be sure that without that, especially when you're setting up a trust for other beneficiaries to benefit from it, you have to be sure that you still have some assets to take care of yourself, because the best trusts are irrevocable. You understand? So that's something you need to take into consideration, because remember, you need to make sure your overall wealth planning is integrated. You understand? Then secondly, on terms of it will being contentious, he said he's right about that. It's a very contentious issue. My own will, I put a clause there that says whatever I give anybody is conditional. It's conditional to be no dispute. You can take a step to enforce your right, but if you're going to cause a dispute, then you lose whatever you are getting. And I put that clause there just because of the point he raised that, issues of wills, people fight, like Pastor said that, it becomes, I really like that wealth becomes warfare, Thank you.
Thank you for that input, Mr. Ayo. This goes to Mrs. Jayola. What is a good will?
Thank you. Well, a good will must have all the, the requirements, for validity. For instance, it has to be written. I mean, that's the foremost. It has to be written because although there are some exceptions, very few, limited exceptions, which applies to people that are, like armed forces, but that's not necessarily a concern. Then, apart from being written, there must be testamentary capacity on the part of the, the testator, that's the owner, the one who settled the will, right? Who, is the author of the will. Now, when I say testamentary capacity, he must, at the time of, giving instruction, to prepare the will, he could actually write it himself, or he could engage a professional to write, because the law provides, for that. But when you want to write a will, you have to have the capacity to write. That is, at that point in time, on your age. I mean, I need to mention that the age, in Lagos, we have the age being 18. I think Lagos and I think Oyo State, but other parts of the country, that is the one that haven't really modified the old Wills Act. So they have the age set at 18. So what it means is a child cannot write a will. You understand? Then there's also the intention on the part of the writer. There must be an intention, to write a will. He must have mental capacity. He must be of sound mind, right? Because I know most of the time, because in our own part of the world, we rarely have, I would say in practice, I can count on my fingers how many people that will walk in of their own accord to say, oh, I want my house in order, please help me, prepare. Most of the time you find people coming when either they are sick, about to die, or there is some concern about, whether or not they are going to, survive. Maybe they are embarking on a journey and they are not sure of, their certainty. But, we'll go into that much later. But for the purpose of, the requirement for a valid will, so the person must have mental capacity, you understand, because those are some of the things. Like he said something during the course of talking about sometimes why wills fail, right? It's because when you have, and I believe it's not just the will, even trust instruments can fail if they are not properly, drafted. So if for instance, if someone waits until he's almost going to die, pass on, his family can contend, for instance, and say, oh, maybe he was influenced there was an undue influence on the part of probably the person that was taking care of him, or maybe if that person eventually is found to benefit immensely from that, we can't rule out that fact. So that's why it's always important, you understand, to prepare ahead. I believe, as like he mentioned, that when you want to prepare, when you want to do proper succession planning, you have to do it as early as when you start making that money. You understand? And I want to add to that, if we want to pass on, there's a rule he mentioned, is share sleeve to share sleeve, right? Yes. Now, I believe even in Nigeria, we find that it's not just the third generation, even second generation, they don't even maintain, what they have. They've squandered it. If we look at the prodigal son, for instance, right? He got his own, like a gift. His father gave it to him outright. He didn't wait, until his father died. Right? He requested for his asset and he got it and he went and he squandered it in his father's lifetime. You understand? So, I've said mental capacity, sound mind, age, right? It must be written, right? Then it must be clear. In terms of the you must name beneficiaries, because, for instance, you can have a will. That brings me to another point here. I remember there was this client, a friend, unfortunately, whose husband passed on, right? And also a client. I remember that there was this will that was prepared. He actually, in his own case, the case of someone who had the fear that he would die. He had this illness. He didn't disclose, actually. He didn't disclose on time to his family. So his family didn't even know that he was sick. You understand? And as the sickness progressed, he now decided he was going to engage a lawyer. Unfortunately, he got someone who didn't have the capacity, or I would say the skill, to do a proper will. So what happened was he had his assets listed. He mentioned, the beneficiaries. He didn't name an executor. That's one. Then when he was in his own case, he even had everything in his account, because we got through that will, we were able to, at least when it failed and went into interstate, right? We had to do letters of administration on his behalf. But in his own case, because we had to use the list of his assets, his accounts, and every other thing, so that helped us. You understand? Because it wasn't just a Nigerian asset. He also had some. So that helped us to have, an idea about what he had. But that will failed because the person who guided him didn't instruct him properly. One, he didn't even have anyone witness his signature. And then he signed as a witness in his own will. You understand? So you can imagine the scenario. So it's okay to draft a will, right? But it's also okay to find out, get information about what you are entering into, and do it well, so that it doesn't, the whole exercise won't be a futile one.
Thank you very much, Mrs. Jayola. My own take home will be that for you to make a good will, you must be in your perfect state of mind and health. And also, you can also be a witness to your will. You must be witness, there must be witness to attest to that goodwill of yours. Thank you very much, Mrs. Jayola. The next question goes to Mr. Felix. From your experiences, what are your top 3 most effective tools for wealth preservation and transfer in Nigeria, and why?
Looking at the mechanisms for wealth transfer, Nigeria will, I would say trust. I will take, for a second, I will take deed of gifts, and then will. Let me first and foremost say that in wealth transfer, there is need for the person transferring wealth to be deliberate. Wealth is good. It is sanctioned by God that we should be prosperous. Our laws also support that we should own property. Property cannot be just taken away from you. It's a fundamental right that cannot be easily taken away from you. So if you, and it takes a lot to acquire assets. So if you acquire assets, it is not enough to just acquire just assets. It is important to be deliberate about what you do with the asset and what happens to the assets after you. So when I say trust, number one, because in your lifetime, you are able to see what will become of your assets when you are not here. You set up a trust, you leave it with someone to manage on your behalf. You are able to see how the assets are being managed, so you can be rest assured that when you are not here, it will be managed the same way, with maybe little differences. So I think it's safer, because you are not likely to just entrust your asset to anybody. You are like my colleague said, you probably would have conducted your due diligence and assure yourself that this person can manage the assets. I also like the fact that my colleague also talked about the prodigal son. One of the things that strike me about the prodigal son is, was he trained to handle assets? Did he know what it took to manage assets? If he knew what it took to manage assets, he probably would have done better. And like Pastor said, asset cannot become danger for the future. Asset was a danger for that man. At the time, he was eating with animals, so he wasn't prepared. So if you are deliberate in what will happen to your assets and you entrust it to someone who can manage it very well, it takes care of a lot of things. I said second, I will recommend deed of gift. Deed of gift, you are deliberate. You look at all your assets. Maybe you have 2, 3 children. You know who can handle what and what is suitable for who. In that like manner, you are making a choice. You are deliberate in what you are doing. Will also does similar stuff, because in your will you distribute, you give to who you want to give. It's also an opportunity to disinherit who you don't want to benefit from your assets. Unlike when there is no will, the society decides for you who will handle what and who will do what. So in this order, I will recommend the transfer of assets.
Thank you very much, Mr. Philip.
To add to what he said, he's mentioned very powerful 3 points, but I want to bring to bear a very important factor that we need to consider. When it comes to writing a will and all that, and someone passes on, we must realize that it takes time. The probate process is time consuming. Now, you need to factor in, okay, how will my family sustain themselves? Because at that point, the assets are frozen, the bank accounts are frozen and all that. You may not be able to, the beneficiaries may not be able to have access. So the person writing the will or the trust must factor that in, okay, and say, okay, how would they, especially when you have, very little ones and all that, guardianship and all that, you must factor in how they are going to sustain themselves. So I would like to also add that the person, or we had life insurance. Life insurance is very, very critical because it provides the cash flow while the probate process is ongoing. Thank you very much.
Thank you very much. I'm sure we're all enjoying ourselves. We'll go to the questions online. Thank you for all those that have been dropping questions. I would also just wanted to ask that we'll take questions from the floor. 3 people. So I would like to identify the 3 people. Who are the 3 people? Mr. Esamon, Mr. Deletu. Who is the 3rd person? Bemi, 3. Okay. Can we all come to the front? Pending that, I would ask, while you guys are getting ready, okay, I'll ask this question. Who is qualified to determine what happens to people's wealth when they die without a will? Please share case studies of how siblings' disputes were resolved without involving the court or making a mess or even losing the wealth. Jai? Who is qualified to determine what happens to people's wealth when they die without a will? That's the first part. Please share case studies of how siblings' disputes were resolved without involving the courts or making a mess or even losing the wealth.
So the first thing is when someone dies interstate, the laws of succession, interstate succession takes place, or the customary law, depending on, what the testator, the law, or let me say maybe, for instance, if I don't know much about Igbo customary law, but I know that as a matter of fact, the male, are meant to be the ones who, subscribe, and some parts of Yoruba, customary law too. But the interstate law of every state, where the person is resident, automatically takes, precedence over the management of the estate, you understand, and determines how the assets are going to be distributed. And most of the time, of course, we know that it won't be in the interest of, it won't go with the intention, you understand, of the testator. That's one. Then it follows the rule of the wife first, the children, then parents, because that's the order. So there's an order of priority depending on who survives, the deceased person. Then the question about how you could resolve, well, currently there are various multi-door courthouses available now, even mediation mechanisms, right? I don't have a particular example, but I know that most of the time when people have issues and they need them resolved and decide to go out of court, it's effective too. The only thing is they both, everyone concerned must come with a willingness, right, to have the matter resolved. They should be willing to give in. We have this rule of negotiation where you don't go win-win. You have to find a way where you want win-win, so both parties win. It's not like you hold on strongly to your position. For instance, like he mentioned the case of Chifawe F.R. Williams. Now, in that case, I believe, the children should have regard for each other. Their father had 2 children first, but he had 2 others, and I believe it was only one mother, right? So are they saying they are denying the fact that their father and their mother, their parents actually gave birth to other siblings, or their parents shouldn't have had those siblings? You understand me? So I don't think that should have even gone as bad as that, because I've even seen scenarios where even those where the father had other wives, they do come together and have some form of, relationship where even the children at least, relate with each other. Of course, I know it's not, in all cases, but I believe there are channels where people could. And by the way, even the probate registry also provides opportunities. They don't necessarily have to go to court. They give them the opportunity to talk amongst themselves and find, a meeting ground, you understand, to resolve the process of sharing, the wealth of their progenitor. Thank you.
I want to add something. One is about customary law. So we have some customary laws that are discriminatory of genders, but the Supreme Court has said that such laws are not valid, especially when it comes to Igbo tradition. So the Supreme Court has said such customary laws are not valid. Then secondly, when it comes to sibling rivalry, now typically your advisor, whether it's your legal advisor or your financial advisor, is just to advise you. You make your choices, how you want to distribute. But what I sometimes tell people is that some of the cause about dispute is preferential treatment. somebody feels, oh, someone is getting this, another person is getting that, you know. Of course, there may be reasons why the testator decides to do differentiated treatment, but I always say, and this is not a legal issue, this is just a practical issue, that I always believe that one of the best ways to avoid disputes among siblings is treat everybody equally in a will. That is one of the ways to mitigate disputes. But like I said, you know, in the terms of who you give what or what, that's always a personal choice. Your advisor is not really to advise you how to distribute. It's just to advise you how best to go about it, not your individual choices. It's just to advise you on the legal and financial aspects. Thank you.
All right, thank you very much, Mrs. Jaye and Mr. Ayo. Mr. Benjamin, this question goes to you. How well do private trusts work in Nigeria? Can I get trusted people act as trustees to manage my estates? In essence, do trusts have to be managed by registrar trustee company to be successful?
Not necessarily, because the trustee can either be trusted persons or an institution, depending on the arrangement. It's a private arrangement. Let's note that. Very private arrangement, and it's a legal structure. So it's not necessary for you to approach, you know, an institution, the well-known institution that we have. It's not necessary, but it's many times, most often than not, advisable, because that gives some level of, how do I say it, governance structure and organizational, how do I say it, organizational clout to your legacy planning. You can appoint trusted friends and they can fail you. The person is, okay, it's a living trust, right? During the lifetime of the person and all that. Now, let me mention this. You can set up a trust for many things. It's not necessary for your benefit. You can also set a trust for yourself. You being the beneficiary, for instance, for what we call medical power of attorney, where you are saying, okay, I'm not sure, maybe something may happen, I may become invalid, I'm unable to take care of myself. Let me just set up a trust that will be paying the medical bills, taking care of me. Oh, person could set up a financial power of attorney. Okay, I may not be able to sign checks, I may not be able to do this. Let me just set up this trust that does this. You can set up an education trust. You can set up a philanthropy trust. For instance, I came across Alfred Nobel, the person who founded Nobel Prizes. So, you know, it set up what we call testamentary trust. In his will, he died in 1896. He wrote that, okay, this large portion of my wealth should be invested in this, right? Invested in so and so, and then the returns should be given as prizes, should be given as cash prizes to people who distinguish themselves in different areas of calling. So, and he died in 1896. What he did was he appointed 3 institutions to monitor that. 3, not 3 individuals, 3 institutions. And now it's over 100 years. And the Nobel Prize is still waxing strong. So I would err on the side of appointing an institutional trustee. Thank you.
Sorry, I want to add though, when talking about the tool, we understand, even though yes, we'll be mentioning interest, you know, wills, gifts, let me say the quantum of what you want to pass on also matters, because that will also determine what cost you are going to incur in the, you know, at the end of the day. Because for instance, we are talking about trust and you are looking, you know, at approaching an institution. You understand, all these companies, trust companies and all that, they charge. So it's not as if it's going to, and their charges might not necessarily be, I mean, commensurate with the value of the assets you are trying to pass on. So it's important that you have knowledge about, I mean, what do you want to achieve actually? The quantum is also important in deciding which of the tools you would eventually settle for. Thank you.
All right, thank you very much for the inputs, Mrs. Jaye. This question goes to Mr. Ayo. Please Please, how do I separate my personal assets from my business assets in my trusts? And will without a conflict of interest or taxes? The second question is also, can you speak more about the Blue Book, and does it apply in other states?
Okay, thank you. I'll start with the second question. So the Blue Book in Lagos State that I referred to has to do with what is called fair market valuation of properties. So what Lagos State has a system in place that every 10 years you're meant to value property. And so let's say I buy a property today and I want to apply for governor's consent to that property. I'm going to pay 3% of the value to Lagos State. Now, like I said, the last time they did the valuation was 2015. So they've now done the valuation, and the little I've seen of that valuation is almost now at full commercial value. You know, in terms of typically what's the price will be between a willing buyer, willing seller in an arrangement. So the Blue Book, in summary, provides for valuation of properties in Lagos State. It's done every 10 years, you know, and it's what Lagos State says what the fair market value is. So and just for another analysis, typically in the past, the fair market value has not been the same as the commercial value. But it seems now Lagos State is now, this new review is more like commercial value. And I'll give another example. In the probate registry, let's say you have shares now, and because they will value your estate, and then you pay 10% to Lagos State. So if you have shares in a company, let's say you have shares in MTN now, and if it's 500 naira, and I don't know if it has changed, but the value for the purpose of your estate is 1 naira per share. You know, each company is listed on the exchange. I think, is it 1 naira or 1 naira per share? So the value is not commercial value. It's nominal value in that sense. So that's what Blue Book is about, valuation and things like that. Now, he said the first question had to do, how do I separate my personal interest from my commercial interest for the purpose of a will? Sorry.
In order to avoid conflict of interest or taxes.
Okay. So now, in terms of conflicts and this is for wealth planning and succession. Okay. So in terms of conflict of interest now, so typically you have your personal assets. You can hold these assets either individually or through an entity. Now, if you have control or ownership of a company, you also have, you could own it now. One person can be a shareholder of a company, you know, so you can own it, either you own it 100% or you own it with other people. So when you want to do a transfer, you obviously, private ownership, what you own, you can decide which mechanism you want to use, whether you want to sell it you want to transfer it by a will, a trust, or even through companies, you know. I'll still make a point about that. For the company, it's your own entity, it's your own ownership interest in that entity that you can transfer. You understand? So if you do that way, then you avoid the conflict of interest, because you're transferring what you own in that asset. And then when it comes to properties and ownership of properties, another investment or wealth transfer mechanism is actually to own a property through a company. I'll give you an example. So I have a company in my personal name. I buy this company, I pay consent to Lagos State to it. So if I want to transfer this property to anybody, whether it's a beneficiary, you know, whether it's to a trustee, the governor of Lagos State will still need to consent, or whether it's through a deed of gift. The rate for deed of gift is a bit less than regular rate. Governor of Lagos State still needs to consent to that subsequent transaction, and I'll still pay 3% of government's Lagos State's value of that property. So that's one scenario. The second scenario, if I had bought that property through a company, I set up a company, that's his only business, just own Property A Limited.
So I own Property A Limited, and Property A Limited gets consent of the governor of Lagos State to that acquisition of the property. I pay the taxes. If I want to transfer my interest in that property or transfer that property to somebody else, whether it's a beneficiary, whether it's a trustee, all I need to do is to change ownership of that entity. I transfer my shares and resign as a director, appoint somebody else as a shareholder, a director. It could be a trustee, it could be the executor of my will, it could be my children. Then that second step, because it's the ownership of the entity that's changed, not the ownership of the property. The company still owns the property. I won't need to pay governor's consent again, because the company still owns it. It's just the ownership of the property that's changed. Yes, thank you.
Thank you very much, Mr. Ayo. So this question goes to all the speakers. First question is, how do I set up a trust fund? Second one is, are there safe and secure trust companies in Nigeria? The third one is, can you refer us to trust companies, and can we have shared scripts or slide of all presenters? That will be for the committees later.
Okay, I will answer the first one.
Okay, so I think we've answered that question. Yes, I believe that question came from online. So we are not going to give you recommendation on trust companies. Like Mr. Benjamin has said, do your research. They are regulated by SEC. So we believe that you can trust them if SEC can trust them, not me. So before we go on, we'll have the questions. The three people that want to give questions will now take their questions now. Mr. Eson.
Thank you, everybody. You guys have done very well. I've learned so much. Mr. Benjamin, I have a bit of background in tax. And when you were talking about trust and tax implication, have you read the 4 Tax Reform Acts 2025? Have you had the chance of reading them thoroughly?
Not thoroughly,
Okay.
I must confess.
So I'm looking at section 191 of the NTA. It says that if you're trying to engage in tax avoidance, you know tax avoidance is different from tax evasion. They're not one and the same. Tax avoidance simply means you're taking advantage of loopholes in the law to the advantage of your client. Now, section 191 is saying you must tell the government what you want to do. Now, if you're setting up a trust for the purpose of avoiding tax, do you think that will pass on, just wait, do you think that will pass under the NTA? Which simply means that you cannot take advantage of any tax loophole without telling the relevant tax authority that, look, I want to take advantage. Then secondly, how do you prepare a trust so that you do not suffer from what I call double taxation? You know, if you look at, again, go back to the NTA, it talks about the principle of looking through. In law, we call it lifting the veil. I can actually go behind what you're trying to do and say, no, you can't do this. Now, if somebody is saying, I'm doing a living trust, does that remove his or her tax liability? Don't forget that as a trustee and manager of that trust, you're also susceptible to tax. So you're dealing with double taxation over the same principle. We used to say that trust is an efficient tax management system. Thank you.
Okay. Thank you very much for that. Those very apt questions. For the first one, I did give a disclaimer subtly by saying that you don't use living trust as a tax avoidance tool. You don't do that. And I said that some, just a minute, the ultra high net worth leverage it as a tax avoidance tool. But for us in this scenario, we are not advised to use as a tax avoidance tool. It's very simple. You are setting up a trust to what? As an entity for continuity. So the objectives must be stated clearly. Why am I setting up a trust? When you approach a trust or a trustee now, they'll give you a form to fill. And in that form, you have to state clearly exactly what you want you to set the trust for. What are the objectives? Like I said earlier, it could be several things. It could be all-encompassing, or it could be just strictly, okay, to serve to take care of my health, or to take care of my beneficiaries, to offer guardianship. For instance, I came across one of the emirs in the north, I don't want to mention names, when he had issues with the government, the state government, and he was removed as an emir. So he said something when he was interviewed. Later he was reinstated. He said something that really, really made me admire him the more. He said that one of the things he did was that he set up an education trust for his children to take care of his children's education to their master's level. So there's got to be stated objectives for setting up the trust. It shouldn't be a tax avoidance instrument or vehicle. Now, for the second one, I'm trying to remember what the second one is. The second question. Okay, double taxation. Now, when you pass your assets to the trust, they are now owned by the trust, or by the trustee. The vehicle that you've set up, they are owned by the trustee. Now, for yourself, you still pay your tax, you pay your personal income tax. For any other assets that you still have that are not placed in the trust, you pay taxes for them. Now, from the moment you hand over your assets to the trustee, it is the trustee that takes care of the obligations and everything and all that. I hope I've answered to a large extent. Thank you.
Okay, in addition, sorry. So on this point of tax avoidance, so it's important to note, as I agree with all you have said, that globally there is a push to reduce tax avoidance and tax management. In fact, I read that, I haven't read all the tax administration laws, but I read there is a provision that now says that even the income from a trust is now taxable. There's a separate provision on that, and I always tell people, especially when it comes to taxes, expenses, and things like that, that you need to realize that something can be both a cost and an investment. You understand? Some people, for instance, don't want to register businesses because they don't want to pay tax. They don't want to comply. But there are also advantages. So it's a personal decision, but globally, there's a push against tax avoidance and then tax evasion. That's something we need to note, and that even that's also coming to us now in Nigeria. Thank you.
Let me add that the issue of double taxation is practically part and parcel of the Nigerian tax law. You get to pay tax at different levels on the same property. If you are using trust, for instance, the deed of trust, you are registering the deed of trust. The issue of consent, stamp duty registrations will come up. You have to deal with it, and it gets to the hand of the trustee. Manages the property, like you said. Capital gains tax come now. If it's an entity, the asset is taxed, the gain is taxed as in personal income tax. Or if it's an entity, a corporate entity, it's taxed based on what is the value of the company. Is it a small company? Is it a medium or large company? But look at the other devices. If you use trust deed, you are going to register the trust too. Okay, and then whatever happens to the asset too, you are still going to deal with at what level will tax issues come up. If it's through a will, you are applying for a grant of probate, or if it's there's no will and then you are going through letters of administration, you will pay estate fee. Whatever they are doing with the asset, they are still going to pay tax on it. So I think it's practically part and parcel of Nigeria. We have to keep canvassing this issue and talking to government to harmonize taxes in Nigeria?
Good afternoon, everyone. My name is Bemini, and I work in the elderly care space, so this is a topic that is very important to my profession. A couple of questions I have, given the things we see in society. So very recently, I had a client whose kids sold the house she was living in. So she doesn't have accommodation as I speak with you. And there's so many things we see, and we've had this topic discussed at forums where I have senior citizens seated. And the outcome is always a mixture of, it's a very complex process. Both the will, the trust, what have you, it's expensive, and it's not something a lot of seniors gravitate towards, except for the ultra rich. So please correct me if I'm wrong. Now, I would like you to emphasize more on the application of the deed of gift, because it was just silently mentioned. I want to know if it's the best of the three options in terms of the instruments we've discussed today, or what are the pros and the cons. You also mentioned today that wills fail. We know that a lot. But I heard today that trusts fail. Please give me a case study of a trust that has failed and tell us why and what we need to learn from that. My last question would be, how do we, or what do we advise when it comes to senior citizens? How can they truly protect themselves? Now, I'm not talking about when they are gone. When they are gone, they can't be bothered. So if the children want to fight, they can fight for all they care. But whilst a lot of them are here, they've worked. A lot of them have made money, they have assets, but they are living in penury. We're having situations where there's more entitled children who even want to take of what their parents have worked for without caring about the well-being of these elderly ones. So in all of these conversations, what is going to help that 80-year-old woman to live well in old age, given that she probably has pension, or she has one house or two houses she may be receiving rent from? What can be done to ensure that the last years, be it 5 years, be it 3 years, they can live well? Is it a trust they need to set up for old age? And then whenever they die, they deal with, the children can deal with whatever is left of it. What can be done? Because I think the whole thing about legacy being passed on is one thing, but we're seeing now that seniors are not even enjoying their old age. They're not able to. So what can be done? Thank you.
Okay, let me start. Let me answer the first question. I'm an advocate of wealth creation, but I've now realized that wealth transfer is as important as wealth creation. The energy that we put into creating the wealth, we must put the same energy, if not more, into putting together a proper structure. We must be very intentional. Very, very intentional. Now, I want us to remove that mindset, that idea that wills, trust, it's complex and all that. It's a mental block. It causes some kind of, it can deter someone from taking action. And by the time the person is taking action, it might be too late. So let's remove that from our mindset. Let's cultivate the attitude of, okay, since I've intentionally created this wealth, I also want to intentionally put together or put in place a structure to do this, this, and this. Even in my old age, what will take care of me? And that is where wealth advisors come in. We've been talking about trust and wills. That is where wealth advisory, investment advisory comes in. Sometimes you may not be able to figure all of these things out by yourself. You need wealth advisors. You need investment advisors. Now, everything we've said there are no hard and fast rules. It has to be tailored to you based on your unique context. And that is where the advisor comes in. The wealth advisor or the investment advisor. or we call them financial advisor, they look at you. You know, it's a whole, and it's private, it's confidential, it's fiduciary. Nobody will know that you've employed or engaged a wealth advisor. They help you look at your unique context, your horizon, your risk appetite, your plans, your goals, your beneficiaries, everything will be taken care of, will be factored in, and they will come up with a solid plan. Of course, it may not be necessarily foolproof, but when you have a plan, it's better than having no plan. So many of our, I'm sorry to say, but many of our elderly ones did not put the right structures in place. And it's telling. Or maybe we should say that they did not have the information that we have the privilege of getting this after. Let's put it that way. So now that we have the privilege of listening to this, it would be so, how do I say it? So irresponsible of us to repeat the same mistakes. So structure is very important, intentionality is very important, and that is where you need wealth advisors to serve as that bridge that help you to They consider everything, and then the advice. Of course, the final decision is still yours. But they will advise on the best approach that will work, and the best template that will work for you. Thank you.
Thank you very much. The next question.
On the issue of deed of gift, because she said we have been a bit silent on the deed of gift. It is rarely used because, especially when you still have interest in the property, because once you give me a property under a deed of gift, it's mine. So you keep off the property, practically speaking. Well, if it's a property you have interest in, you see like rent is coming in, with which you expect to maintain yourself, deed of gift will not be appropriate. So a trust will be much better, because in the trust you are the beneficiary. The trust company manages the asset for your own benefit, and the conditions, the terms, all the structure to be put in place to ensure that your desire is brought into effect as stated in the trust deed. So the situations are quite different.
All right, thank you. I just have this question that how soon can one start thinking about putting up a trust or writing his will as a young man? And can you start your trust based on salary that you are earning?
Okay. My view is that the moment you begin to acquire assets, you must also begin to take decisions on what you want to do with it in your lifetime and afterlife. What is the motive for acquiring assets? Comfort, prosperity. You want to enjoy, you want to feel safe, security. You want to be sure that when you are old, there are things to take care of you when you can no longer walk again. So it's about safety. So you cannot be sure that you are safe by just acquiring assets and not determining what you will do with it and how you want it managed. Thank you.
Okay, to add to that, the lady that came in that asked those questions, she mentioned certain things that I want to quickly address. The first has to do with cost, right? Now let's look at this. This way. Will may cost you less in the short run, but in the long run, when the person passes, the cost magnifies, because the probate process and all that. By the time the stuff is coming in, it's costing a lot, depending on the portfolio. But a trust, it can cost mildly initially, but in the long run, it saves a lot of cost in the long run, both in the lifetime of the person and when the grantor passes on. So, in terms of cost effectiveness, over a longer, a trust is more cost effective. Another thing I also wanted to address is with respect to when should I start. Let me quickly lend my voice to that. Let's look at the different items you can put in a trust or in a will. cash, you have properties. There are other kinds of investments or stuff you can put in the trust or in the will. If you have creative stuff, creative investments,
Intellectual property.
Publishing rights. For instance, was it last month, the children of a certain well-known producer, if I mention his name, in the US, were able to license. They sold the publishing rights of their father, and everything went American because the man had a trust in place. Everything had been set up, and it's benefiting the children, and the benefit them. They're getting the most benefits from the intellectual property of their father. So you don't need to have all the money in the world. As a middle income earner who has started acquiring stuff, if you have shares in a company or you have certain shares, you can put it in a trust. It depends on the objective, right? So you can start. That's what I'm trying to say. Thank you.
There was a question that we missed. When a trust fails.
Okay, I remember that too. Now, candidly, a trust fails when it is not properly structured. When it is not properly structured, just the way the will that the gentleman made failed because it was not properly structured. A trust can also fail because of lack of proper structure. Now, that was why I was against having, of course, I'm not necessarily against it, but it must be done in an informed way. When you appoint maybe certain friends or family to serve as your trustees, they may miss out on certain things. For instance, in registering the trust deed and all that, all of those things, they may not know. But when you appoint a proper institution, that would not fail. Example is the Alfred Nobel. It's over 100 years. He passed on in 1896, and it's still working till today. So when you have proper structures in place and things are done the way they're supposed to be done, the trust would not fail. Thank you.
Let me add that when a trust fails, when a trust fails, when a trust fails or will fails, then the result is letters of administration, because it means that it's as good as the testator or the settlor did not put up a trust or write a will. So it means that depending on the state, for instance, if it's in Lagos State, a letter of administration has to be applied for, and the assets will be distributed as the law. The law does not cover everything, but it gives a framework. Depending on the marriage, for instance, the marriage between the deceased person and a spouse. If, for instance, they are married at law, under the Marriage Act, the one I call Oyibo kind of law, the wife has assurance of minimum of 30% of the assets of the estate. And that is if there are no dependents. But if there are dependents, it might be less. It can also be depending on how they also agree in the family to distribute the assets. Customs will also come into place for the rest. For instance, in Yoruba land, there are two major customs, the Ori Ojori and Idigi customs. So if there are several wives, then the children of those wives will be looked at from the wife's perspective. If there are 5 wives, for instance, and there are 15 children, and the children mostly don't come in the same number. One might have 1, another wife has 3 children, another one has 5. If the custom is Ori Ojori, then it will be split equally among the children of the 5 wives. But if they are using Idigi, it's split equally. If they are using Ori Ojori, then it will be distributed based on the number of children. It means, for instance, if there are 15, the 15 of them will share equally. But most importantly, and someone asked about it, how issues relating to distribution can be resolved through letters of administration. I answered that it takes a lot of understanding among the beneficiaries. More often than not, one person wants to outdo the other. One person believes that this is what he should be entitled to. It takes a lot of understanding among them, and that is why we converse at this level that once you are acquiring asset, you should be deliberate on not only how you want it managed in your lifetime, but in afterlife. That's the only way you can be, because like Shakespeare said, there's no art to find the mind's construction in the face. Almost everybody had talked about my former boss's family, the Williams. I try not to talk about it because I know a lot. I have a lot of confidential information. But all I can say is that there's no art to find the mind's construction in the face, because the father trusted that all will be well. But it's not so. Thank you.
Praise God. All right, we are in the church now, so I can say praise God, right? Thank you so much for this rare knowledge. Like you mentioned, some of our fathers don't have privilege to it, so I think it's the first time I'm hearing anything like this, so I'm very grateful. Thank you so much. And on the premise of having a proper structure of a will, I heard from a friend that if you have a will, okay, let me ask a question now. Does it take an attestation of your relatives to validate a will? Is it a compulsory thing? What if you're not comfortable with that? What if you don't have someone that you are comfortable with to come and attest to it? Is that statement fact? Is it true? And if it is true, what if you are not comfortable with it? Can you do otherwise? Can you avoid it? That's number one question. Number two is that how do you manage a will of a property that is joint owned with your spouse?
Sorry, say that again. How do you manage?
The property is joint owned.
Okay.
But only one person has passed. Is that what you mean? Or both are passed?
A will that is a property that is joint owned with you and your wife, for example. Do you have the right to decide how it will be shared?
Okay.
Is that clear?
The law is nemo that quod non habet, as lawyers will say. You cannot give what you do not have. If it's a joint property, we assume that it's 50-50. Meanwhile, joint doesn't have to be 50-50 always. But let us assume 50-50. You can't give away, you cannot bequeath more than that 50%. And it's best for you to sit down with your spouse and agree. Both of you can write will together. Give your own, she gives her own, because at the end of the day, it belongs to you. But if you want to, you can only make a statement as to what is your own share of the property. And of course, at the demise of one of the spouses, the property automatically belongs to the other. On the issue of attestation, I think it's about the least difficult.
It's attestation by a relative. Is it required?
Yes. It's not required. It's not, anybody can witness. Yeah, that's why I was going to say it's about the easiest thing. Anybody you can call anybody. In fact, they don't have to know the content of your will. It's enough for them to know that their own is just to ascertain that on so date, I saw Mr. Adeyemi signing his will. The idea and the two of them should be together in the place as the law requires. But it's not specified who can sign. It can be your relatives, and they may not relate to you. It can be anybody.
There's just one bit though. Calling anyone, it's not calling anyone, just anyone, right? You want someone that would definitely outlive you, because when the process for, proving comes, you want those people to still be available. Then they must be credible, because we have cases where someone who attested eventually came back to say no because of some, interest, you understand? I mean, there are so many scenarios, so you have to bring someone who you can trust, who you know will be able to at least speak on your behalf when you are not there to defend yourself. You understand? So.
And in addition, you need 2 witnesses. I think that's the consensus. You need 2 witnesses. Then to the first point about joint property and owning property with another person. So it's a very important issue because you could have joint property or ownership in common. And for joint property, you know, the right of survivorship, like he said, your own share. If it's in common, if you own the property with somebody and it's not joint property and it's deemed to be ownership in common, your survivors might not have that right over that. So you also have to be careful when you acquire property with people. You need to be clear what kind of ownership interest is it. You need to be clear what you want to happen to your ownership interest. Thank you.
To further add to that, I would say that one of the first steps when you're considering drafting a will, you know, considering legacy planning, I've said it earlier, I'm going to reiterate it. You need a wealth advisor. Thank you.
All right, thank you to the speakers. We have a series of questions from the online audience. And speakers, kindly answer this question in 2 minutes. Thank you. So this question goes to Mr. Felix. How long can trust exist? Does it expire without a clause? Second question is, next of kin without a will. What does next of kin means? The third one is, please share a case custody where not writing a will makes sense. The fourth one is, what is the future of a will, trust, or gift, deed of gifts?
Okay, please, let's go over it. The first, please. Let's go over it.
The first one is, how long can a trust exist? Does it expire without a clause?
Okay, now a trust is a succession plan. If there's need for it to change or expire, it will have been stated in the trust. So you cannot import anything. When what one desires has been reduced into a document, you cannot import. So if there's no expiry in it, the question of expiry cannot come up.
Next one is, next of kin without a will. What does next of kin means?
Okay, next of kin means that someone who can be called upon when there's probably an emergency or when there's need to say some things about the situation. In banking, there are forms you fill, they ask you to put next of kin. So in case if they need to call someone, the person comes up. Being a next of kin, I know that is where the issue is, does not confer any right on the next of kin per se. It does not give you any rights. It's just that you are recognized as a relative or a person who can be called if there's an issue with the person in issue. But let me quickly say this, that sometimes, as much as we say, because it's very easy for us lawyers to say there's nothing about next of kin, there's nothing there. Yeah, but I've had some experience where it might not have been tested in the court, and I'm really hoping that this will be tested in court very soon. I have a live situation that we are handling. The man had 2 wives. The first wife was married under the law, Marriage Act. Of course, like I said earlier, is protected by law. The second, of course, once you are married under the law, you cannot marry any other person. The second marriage is invalid in law. But the man lived the last 10 years of his life with that second wife. And in most of his documents, the woman was recognized as his next of kin. I said he lived the last 10 years with her. So when he was ill, it was this woman that was with him. At the hospital, she was the next of kin. And so when the death certificate was issued, it was delivered to her. In his place of work, in his biodata form, he put it down that he had 2 wives. So the company was to pay his beneficiaries gratuity, which could be paid without going through letter of administration or probate. But because the company recognized that this one had 2 wives, they declined to give it to the first wife. They said the only thing they could do was to leave it to go through administration. Of course, they didn't want to go through letters of administration. At the end of the day, they had to agree to share the property. Okay? So that way, next of kin has given the wife something. So when we say that he cannot give anything, we might not be absolutely correct. Now, the other assets of the estate today have not been administered because the first wife cannot proceed to process letter of administration without the death certificate. Okay, the woman holds on to it. She has the death certificate and she says, look, before we can go to process letter of administration, we have to have an agreement on how the estate will be shared because I have a stake in it. And sincerely, if you look at the situation, it was the man who created the issue. He lived his last 10 years with this woman. This woman tended for him, took care of him. So he recognized that this woman should not go empty-handed. But the law does not seem to be saying that. So that's why I think that the court will have something to say about this. Thank you.
All right, thank you very much, Mr. Philip. The next question is, please share a case study where not writing a will makes sense.
Not writing a will makes sense. Let me say it's a choice. Not writing a will is a choice. Some persons don't, they just don't buy the idea of writing a will. I think it's fading now. Some persons believe that it is when you are close to death, or when you envisage that you may die soon. But it's not correct because everyone owes the debt of dying someday. So no one knows when. But if a person really feels safe that he has put the necessary arrangement in place, he understands his children, he knows, which I do not agree with anyway, he knows how they are likely to act, how they are likely to deal with the assets, there will not be issues, then he might not need to write a will.
Okay, let me quickly add to that. There's a life situation I am aware of. To prove that not writing a will does not make sense. Yes. Okay, so my grandfather from the maternal side was a very wealthy man. He had 21 children. He had about 6 or 7 wives. And he told his children, he said, he said it in Yoruba, I will interpret it. Ogun ti mo ni fun yin ni education. Anyway, you want to go to doctorate level or PhD level, I will sponsor you. My properties are not for you. In other words, he was saying that, see, my legacy for you, my children, is your education. He told them point blank. But you know now, when he was passing on, in fact, it was recently that I found out in a book that was written by the doctor that cared for him. He said when he was passing on, he said something that his greatest regret was marrying multiple wives. Because that spoiled the entire thing. As soon as he passed on, every man for himself. Some of the children went and sold some of those properties without the knowledge of, many of the children did not go to school. In fact, it led to chaos. So, not writing a will cannot make sense. Thank you.
Thank you very much, Mr. Benjamin. Mr. Benjamin, this question goes to you. Can an individual use a property that has been transferred under trust fund to take a loan?
Okay, so now, what a trust does is it separates ownership from enjoyment. That's one of the major benefits of a trust. It separates ownership of an asset from the enjoyment of the proceeds of the asset. Now, the ownership of those assets, when you put it within a trust, is by the trustees. So that means the beneficiaries cannot sell. They can only enjoy the benefits, right? Or the proceeds. So that's one of the major, because especially when the grantor or the settlor, the person who wrote who set up the trust, is unsure of the managerial or the management capacity, capability of his words, of his children, can set up a trust and give conditions, certain conditions. That's what a trust does for you. It's a control tool for dictating how your legacy should go based on your vision. That's one of the things I wanted to mention. Your vision is very important. What vision do you have for your legacy? And then that vision to drive the instrument you use, whether it's a will or it's a trust. And if it's a trust, what kind of trust are you looking at based on your vision? Set it up. If you are unsure of whether your children will be capable enough to handle the properties, put it in the trustee, in the custodian, in the trustee structure. The children cannot sell it. They cannot sell it. So they can't sell any properties that, especially when the trust deed it states clearly. The trust deed is the trust agreement that is set up that dictates everything. So that means that no external instruction can come outside the trust deed that the trustee would entertain. Thank you.
Thank you very much, Mr. Benjamin. Mrs. Jayola, this question goes to you. Can I change the beneficiary to my will during my lifetime? Maybe I change my mind on any of the beneficiary. The second question is, can I put on my will that a property should be given? For example, my son and I will put in the will that he cannot sell the property, but he can only transfer it to a family member.
Okay, yeah. So the first question talks about, please say it again, sir.
Can I change my mind, change the beneficiary
yes,
to your will
yes,
during your
you
lifetime?
can, because I mean there are provisions where you can revoke it outrightly, or you can modify it by, making there's an instrument we call a codicil. It's like an amendment to a will. So for instance, like the case of Chief Efari Williams, he had a will made at a certain date in the earliest, stages of his life. When things changed, he could have either, revoked it and created a fresh will, or had a codicil, to amend, some of the, like for instance, the beneficiaries where he had additional children. He could have, used the codicil to incorporate them, as beneficiaries under the will. I think that's, then the second question.
Like assigning a particular property to someone,
yes,
and telling them not to sell it after their lifetime, but to transfer it to a family member.
Yes, I mean, a will is essentially your, intention about how you want your assets distributed, period. So it's, I mean, you just can't say, I mean, there are so many cases of different kinds of, bequest devices and all that. Some people even make provisions for their dogs. I mean, just to tell you how it can be. So it's your choice. The only thing is, what's important is that you follow the formalities for for a valid will, to take effect, and so it can pass through probate and, what's it called, and be accepted. You understand? And then the beneficiaries can, take the benefits thereof when you are gone, that is, because a will takes effect after the death of the testator. Thank you.
I just want to add something to our question. Now, in a will, your choice of executors is very important. Some people typically might choose their family member and things like that. But, depending on the nature of your asset, you're looking for competent people that can manage that estate. You're looking for trustworthy people. You have to be somebody, because that person is the trustee, you're in a position of trust. And then somebody that also can make sure your wishes take effect. because you are dead, you know, you are not going to be there. You have to, it's the executors that will administer that will and execute the will. So you can't just pick anybody to be an executor of your will. And then by the time you draft your will, if you also have minors, if you have minor children, you might want to appoint guardians. Sometimes the executors and guardians can be the same person, or sometimes, depending on the circumstances, you might have different people. So it's something to take into consideration. Thank you.
Okay, for trust, we also have revocable trusts and irrevocable trusts. Now, for the revocable trust, it gives you allowance to change your mind. You can make changes. You can decide, okay, let me make an adjustment to the trust deed. So it's revocable. That's why it's called revocable. But for the irrevocable loss, or irrevocable trust rather, it's very, 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 very difficult to change. That's why it's called irrevocable, especially when someone is trying to protect himself from certain stuff. I don't want to mention them. The person can do an irrevocable trust. So, but for revocable trust, you can make adjustment to the trust. Thank you.
Thank you very much, everyone. Rather unfortunately, we have to round off now. I know that we have a lot we want to ask. We still have a few questions here, but we have to round off. We were meant to have ended by 1. It's almost 1:30. Thank you very much for all those that have come. Let's appreciate our speakers and our panelists. Thank you so much, everyone. Thank you very much. So, okay, pictures before we go. All right, so I would just say you can still meet with the speakers and the panelists once we round off. If you have questions you still want to ask them. All the information, communications, the learnings that you heard today are those of the speakers and the panelists. They are not the position of Daystar Christian Centre. They in no way represent the opinions, experiences, or expressions of the Daystar Christian Centre. The church will not accept responsibility for anything that you have learned today. We are a platform presenting information to you. Each scenario is different. So let's take it as information, learnings that we will build upon. Thank you very much, everybody. And with that, we'll just give a closing prayer. Father, we thank you for the time in your presence. We thank you for the learnings. We thank you for everyone that has participated online and those that came physically. We believe that all that has been learned, you would enlarge it in their lives and in their hearts, in the mighty name of Jesus. Thank you, O Lord. In Jesus' name we pray. Amen. Thank you, everybody. God bless you.
Can you tell us more about legal aids and the fact that people should join and what you do?
Okay. The legal aid unit is a department a unit in the church. We are all lawyers. It's a unit for lawyers. So if there are lawyers here, you can join us if you have done up to 200 level. We provide information on legal issues and matters. Our focus is to educate. We make opportunities to provide assistance where we can, because, like I said, all issues are different. So our our unit, we assist as much as possible before you move it to a system where you would need to engage a lawyer officially. We provide seminars like you're here. We work with other units to provide legal advisory as well. And we also have one-on-one clinics. Thank you very much. Yes, we will. Legal aid members, legal aid unit members, please come forward.
I wake up with a smile each day. Positive for my mindset, oh no. Put this smile on somebody's face in my own little way. And I go there for you, my brother. No need to feel alone. Go there for one another. But this is journey where we dey. You know, say I'll be here, I'll be here, I'll be here for you. And I go there for you, my sister. You no need to shake. We go there for one another. For this journey where we dey. I go there for you. You go there for me too. Yeah, when you grow, I grow. When you grow, I grow. Nothing go hold us down, down, down.
We are a family, always there for one another. Join us. Daystar, raising role models.